What did you tell me before detaining me?
I told you to walk away several times.
Walk away.
Yes, to walk away.
That's would you call that or consider it a lawful command?
That was definitely a lawful order, yes.
Okay. Do you know under what law that would be?
I cannot say that off the top of my head. I'm sorry.
Okay.
It is definitely a lawful command. You're interfering. I asked several times.
You know if it says like a certain distance?
If what says a certain distance?
The regulation on the lawful command.
What regulation are you talking about?
My safe distance from my public's
Okay.
private space.
Mr. Magoo, that's going to depend upon context.
Right.
It depends on what they're investigating. So what are you asking?
Right. At what distance would have been safe?
You could walk to the sidewalk. You just stay there. That's it. That's all I want. You didn't have to leave.
Man, that would have been so easy. That would have been so easy, right?
Oh, yeah.
Mm-hmm. Still trying to figure out this time though. I was first, right? There was no investigation. So at what point does investigating somebody else's drunkenness determine my arrest?
When I'm trying to assess a gentleman who's high intox and you're interfering with that, that's when that justifies that.
You're interfering with your, would you call it a civil act of checking on his welfare?
Oh,
Yes?
go ahead. You go ahead and answer.
Okay. So still no crime.
No.
You were just helping out.
It's not illegal to be drunk in public,
Right.
drunk and disorderly as you were. That's the problem.
Okay. I was disorderly.
Yes, you were definitely disorderly.
Okay. I was disordering your investigation into the civil matter related to someone else.
Oh, I'm sorry. Say that one more time.
You said I was disorderly.
Yes, you're from.
So in the process, I was, because like it's under 40 seconds, right?
Okay.
So within 40 seconds, I didn't listen to your walk away command when you're trying to investigate someone else's intoxicity and welfare. God bless you.
Objection is the form of the question.
It's a form of question. Knowing that there was no crime, would you agree that?
Or your friend,
Showing up on the scene, you guys were trying to get information about
a fight, an alleged fight.
a fight. Okay,
Once we saw there was no fight,
right, and it wasn't that.
I, your friend,
Right, drunk guy.
yes.
Right,
The guy intoxicated.
let's take care of him.
Exactly.
Okay, so you're trying to take care of him,
Yes.
and what did you think I was doing?
Objection is the speculation.
Overruled.
Did I?
Let's hear.
What I think you were doing,
Yeah.
hindering, being obnoxious.
Okay. If
Wow.
you never showed up, what do you think would have happened?
Objection is speculation.
Sustained.
I just have a picture, Your Honor.
Of what?
Just the night in question, just a picture.
I would really like to see any exhibits
Just-
before you show them to the court.
There you go. Just me.
Do you have a copy for me?
You can have that one.
Great.
Can I show them real quick?
What?
Yeah, I'll give it to you.
No.
Sure.
What's it a picture of? And for what purpose am I seeing this picture?
Identification
Of who?
of me, what was going on before. These.
A picture's gonna tell me all that? You got a picture and a picture.
Well, there's no other copy, Your Honor, so.
No, that's
I
fine.
would have sent it to you digitally, I got. I mean, can I do it? No. Come on,
So what do you
man
want?
here.
Are you gonna introduce that picture as evidence of something or try to?
Oh, I just, yeah, I'm gonna try to.
You're gonna try to. All right, let's have it marked. Defendant's Exhibit A.
It's just identification purposes, really. I see a confused look on your face. Before you guys arrived on the
Confused look.
scene. What was that?
What are you talking about? Who's confused? Look.
Oh, no, but it was. I
Oh,
was
trust me. I think
Everyone.
the sergeant knows more about identification of an object in court than you ever possibly will. So
Right.
I don't think he was confused at all,
Oh, okay. Yeah.
but appreciate your concern. Can we get that marked so we can get this done?
It is marked down.
Thank you. I'm sorry, Ann. I didn't mean to rush you, but sooner or later we got to go home.
Yeah.
A major courtroom setback changes everything. The defendant presents a photo he believes will strengthen his case, but the judge shuts it down on a technical legal rule. In court, evidence must be authenticated before it can be trusted. As this critical proof is excluded, the momentum shifts and the case suddenly appears to be slipping away.
Witness has been marked as Defendant's Exhibit A. Do you have a question regarding?
Do you recognize those two gentlemen?
Yes, sir.
Okay. If you could give your opinion of the two.
Objection foundation.
Sorry.
Sustained.
To what we're wearing, look familiar. That was the same night. Would you agree?
Objection foundation.
Sustained.
Foundation. I'm still trying to get to a crime that I committed, and this is before you showed up. This is I was waiting on a ride, right?
Hold on a second. So the photo that you're showing is an
It's just thrown out.
No, quit interrupting me. The photo, Defense Exhibit A, is a picture of events you know are prior to the sergeant getting there.
Right.
Then how's he going to answer any questions about it?
Like I said, it was for identifications at first.
Of what?
The condition.
You've
of
already been
which-
identified.
The condition of us. I was the one, and I was. Yeah, but like I said, I know what happened, That
Okay,
night.
that's fine.
but I'm trying to prove it, and yeah, but you
Prove,
just
what are you trying to prove?
that not there was no crime.
That picture doesn't do it. I'm not
That was the night
going to
before.
accept the picture. You
Ypsilanti-
can't lay a foundation for that photo.
You're right.
I know that.
That was for identification, like I said, so we can just get rid of it.
So Defense Exhibit A is not admitted. All right, go on to the next thing, please.
Okay.
Yeah, he gives that back to me. Thank you, Alan.
Thank you. Do you recall the presence of alcohol on the scene?
Yes, sir.
Do you recall reporting that there was alcohol on the scene?
Yes.
You did report it?
Yes.
Um,
It says it in the report.
Says it in the report?
Yes.
Okay. Would you consider it to be a significant factor of the night?
Objection.
Which night? Yeah, I'll
You know,
sustain the objection. You,
It's,
you need to ask better questions.
yeah. This is last question. Could you just clarify your duties overall that night in regards to me and my arrest?
Clarify my duties in regards to your arrest.
The probable cause for my arrest. Could you establish the probable cause that you RNO for not listening to the walk away command? Okay. The walk away command is what you're referring to though, right? For the probable cause.
The walkway was your detained. I detained you because you did not walk away.
Okay.
And had you just put the cuffs on smoothly, it'd have been fine. They'll cuff you, when you resist, you tense up, you pull away, that starts the RNO. Then when you strike an officer with your foot, that further strikes that RNO as well. So therefore, you got assault to an officer, you activate your RNO. So that's why you were arrested, sir.
Okay. Did you physically see me assault anybody?
No, I was over there dealing with your highly inebriated friend.
Okay. No more questions, Your Honor. Thank you, Officer. Sergeant.
I have no cross-examination.
I was hoping that was true. You may step down, Sergeant. Thank you. Any other witnesses for the defense?
No witnesses.
Any rebuttal witnesses for the people?
No, Your Honor.
Do you have a motion?
I do. To find over on count 1 as charged, assaulting, resisting, or obstructing Officer Darnell Tyson, and reserve any further argument for rebuttal.
A bombshell testimony shakes the courtroom. The officer claims the arrest escalated from refusing commands to resisting and assault allegations. But then he admits he never personally witnessed the alleged assault. Was there really enough probable cause? Viewers are left shocked and questioning the case.
Response.
Your Honor, I, under MCR 6110F, dismissal to lack of probable cause and insufficient evidence. There's no proof of any harm done. The officer that said I struck him, you know, he also said that I didn't, and he was just kidding. We all heard it, didn't want to play it over again for some reason, but it was pretty clear what he said. And I appreciate the officer showing up to assist my friend with a highly intoxicated cause for investigation. But I do, that does not warrant my detainment, much less my arrest. Yeah, and under MCR 6110F, dismissal lack of a probable cause, there was no probable cause. Anything after that is thrown out and inadmissible. It's under Matt versus Ohio.
Ms. Landy, any response?
No, Your Honor.
Thank you. I don't really need it. Folks, give me 5 minutes. I'll come back with my decision on this. I
excuse the police officers have been here since before now.
Oh no, they're going to be here as long as I am. No, they cannot go anywhere.
Thank you.
What'd you say? I don't think that's what he said, but that's all right. We're staying in recess.
All right. May be seated.
Like 3 days. I'm trying to bring on.
All right. The 14A District Court of the County of Washington, State of Michigan is back in session. The Honorable Judge Jason.
Thank you. You may be seated. All right. Having no additional argument in this case, the facts and circumstances of this case, the people with reference to count 1, the charges as against Officer Tyson, the people have sustained their burden of showing that the offense of resisting and obstructing that officer, Officer Tyson, was done by the defendant on that date and at that time. Additionally, as the court can do pursuant to court rule and statute, court does believe that other offenses were committed during the course of this, which are 2 other additional charges of resisting and obstructing, specifically when starting, I guess, with what I will make count 2 with regard to Sergeant Gibbs, the failure to follow the sergeant's command. And I have to give the sergeant all the credit in the world that he gave continuous warnings for the defendant to remove himself from the area. The defendant then refused to do so. At the point at which also the defendant is being detained and put into handcuffs, there is sufficient testimony that at that point, the defendant committed a separate offense of obstruction at that point in resisting the officers, and then ultimately the one to the kick to the groin of Officer Tyson. So those, in essence, constitute the three separate counts of resisting and obstructing. Therefore, the defendant is bound over to circuit court on those three charges.
Your Honor, can I ask a clarifying question so I make sure
Certainly.
I file a corrected amended information? The court found probable cause for added count 3 and resisting and obstructing, opposing, or endangering which officers? All three?
Yes, all three officers. So count 1 is referenced Officer Tyson. Count 2 is referencing Sergeant Gibbs. Count 3 is referencing Officer Smith. With regard to taking the defendant into custody and his resisting of the handcuffing, as well as, quite frankly, his resisting of, during the pat down, the refusal to acknowledge or respond to the officer's questions can constitute obstruction. So he is bound over on those three charges. Do you understand that, Mr. Magoo?
Still argue probable cause, but I'll let the paperwork from this point forward talk. Your Honor.
Pardon? What are you saying?
No questions over there.
All right. Do you wish to have the information presented to you and then arraigned on that information?
No.
All right, so you're waiving presentation and reading of that information?
Sure.
All right. Defendant having waived presentation and reading of the information. And sir, what plea are you entering to those three counts?
I'm innocent, Your Honor.
Okay. Here are your choices. You can plead not guilty, you can plead guilty, or you can stand mute, say nothing, and the court will enter a not guilty plea for you. Of those three options, how would you like to plead to the three charges?
Stand mute.
Defendant having waived formal reading, standing mute to all three counts. Court will enter a not guilty plea as to all three counts. Pre-trial in this matter will be set for
April 3rd at 1:30 p.m. with Judge Slay.
April 3rd, 2025, 1:30 before Judge Slay.
May I have until noon tomorrow to submit a signed amended information to the
Yes, we'll hold the file.
Thank
And if you do that, that way the whole file can go up.
My goal will be by noon tomorrow.
Fantastic.
Previously, the defendant has accepted email service of motions, but the court be so kind as to make inquiries if he'll accept email service of the signed information.
Sir?
Emails, I can.
There'll be an information which is very similar to the complaint in this case. It will be signed off by the prosecutor based upon the court's rule. What the prosecutor is asking is, will you receive an email and take that as service of your copy of the information?
Yeah, yes, Your Honor.
All right. Thank you. Great.